Hey, good afternoon. My name is Ronaldo Hilton, the Chairperson Designee of the New York City Loft Board. Welcome to our May 16, 2019 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of interim multi-dwelling buildings from commercial and manufacturing spaces to state rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. Before we go into the minutes, we're going to turn over to Ms. Balsam, who's going to discuss an upcoming matter.
So I received an email from Mr. Carver today stating that he's not going to be here and requesting that Jason Frosch of Bora Goldstein fill in for him pursuant to Rule 101-01B. So I want to read that rule to the board. And it says,
Just for clarity, Mr. Carver is
he is the owner's rep.
Owner representative.
So representatives of the special interest groups, of which Mr. Carver is one, right, specified in 29101A, Supra may, in their absence, designate substitutes to participate in discussions at the board meetings when the board, by vote, requests such participation. Such designated substitutes may participate only to the extent permitted by the board and shall not have the right to vote. So the first question is, does the board wish to allow such participation? And if the answer to that is yes, then we can discuss the scope of it. Mr. Carver's email is requesting that Mr. Frosch have access to private and public sessions for purposes of discussion. But before we get to that, the board needs to decide whether or not it wants to allow that designation.
Would this just be for the duration? Is this for the entire duration of his tenure?
So I don't think it's for the entire duration of his tenure. I did ask him if it was just for this one meeting or continuing, and he said should be continuing. I know that his workload changed substantially, and he probably will not be back for the next couple of months. So, you know, at least today, June, maybe July, we don't meet in August.
So unless he resigns, then there's no representation from his position, right?
Right.
I'd just like to provide a little background as to why this is in the rule. Shortly after the Loft Board was constituted in October of 1982, the initial owner's representative, a guy by the name of Tom Berger, had a sister who was seriously ill who resided in Australia. So he needed to go spend some significant chunk of time working on that situation, and therefore this came up kind of right away when the board was writing what were then called regulations, and this provision was instituted, and it's been used a couple of times over the past 30 plus years, but very rarely.
By both sides.
I've only missed a couple meetings, and they were sufficiently unexpected. I got stuck on an airport in Honolulu once, that kind of thing, so there wasn't really time. In those days, you couldn't activate this kind of thing.
No cell phone.
Yeah.
All right.
What's your position on this, Joe?
I think that it's important for the owners to have a voice, so I think to say no, we don't want any level of participation would be unfair, and I would not take that position vis-a-vis the owner representative, because I wouldn't want to see it taken vis-a-vis the tenant representative. When the board was constituted, of course, for the first 30-plus years of its existence, there was no distinction between a public meeting and a private meeting. I think there are two questions that would jump out at me. One is whoever an owner or a manufacturing interest representative designates, should they participate in the private session as well? And then secondly, since Mr. Frosch is an extremely skilled attorney who represents a large number of cases, I don't know how we address the question of whether there's an interest issue there. So, those are my
Let
thoughts.
me just be clear about this. So the designee will not be able to vote, but will the designee be able to
Make a motion.
participate in the discussion?
So the board is allowed to prescribe the extent of the participation. The rule particularly says that, right? Designate substitutes to participate in discussions and board meetings. Such designated substitutes may participate only to the extent permitted by the board. So you can fashion the extent of the participation. So my position on private sessions is that there should be no participation by non-board members in private sessions, particularly attorneys that frequently appear on cases before the board. So I would say yes to public sessions, no to private sessions. Not because I feel that Mr. Frosch, because I feel it could give an unfair advantage to Mr. Frosch's firm in terms of insight into board member thinking. And I don't think anybody should have that access.
All right, I don't want to belabor this point. However, we just went through a conflict of interest board process,
Right.
making sure that all of us have no other particular concerns or interests in the city of New York. Anybody that then sits here will not.
Well, they're not
They're not
voting.
voting.
They're not voting, they're not
Yeah,
deciding.
but nonetheless.
But you could- you could ask
Mr.
I understand, but you could ask
But
Mr. Frosch.
nonetheless, through the discussion, they may be or not be influenced by whatever conflict of interest that they might have in terms of what is going on here and their own personal.
The participation he's having is pretty much similar to what we did a couple months ago, right? Where you asked him to appear and give some, right? You asked some outside folks to come in and speak to you and give you some insight to the board, right? On their opinion on the whole, what was it again?
Usually when we have.
Protect the occupancy.
When we have the lawyers.
The law,
Yes, he's one of
he's
the
a lawyer.
lawyers that was on the panel.
It's the
Yes.
same exact type of access.
I
So,
have no objection.
and to address that, I mean, the board could also say, no private session, no comments on cases, only comments on rulemaking. You could say that. Right? I mean.
That's not what you're saying, though, right?
No, I'm saying, here's how you could structure it. You could say you could participate in everything. You could say, but you can never vote because they're not allowed to vote, period. Or you could say, no participating in the private session, but you could participate in everything in the public session. Or you could say, no participation in the private session, no participation in the public session, other than talking about rules. I think that's a choice too. And obviously, even in the public session, if we were going to say, yes, you can talk about cases, he shouldn't talk about his own cases. Right, any case that his firm is on, he should not be allowed to talk about.
I have a question too. Elliot mentioned the conflict of interest board.
Yeah.
But in addition, when we were put on the board, we were vetted through DOI. It was a very lengthy background check.
But you're a decision maker.
So
He's not.
just because I'm voting, I'm just wondering if there's anything, so someone who's not voting doesn't have to have any
He's not,
background
yeah,
check?
he's not a decider. So the whole thing about the conflict of interest board and the vetting that you go through is because you're a decider.
decider.
Yes, to decide cases.
You could be an influencer.
Everyone is an influencer.
Okay.
My mother is too.
So I gather from, based on Mr. Carver's email, that this issue really only surfaced this morning.
Yes,
So the board has not had a lot of time, the staff has not had a lot of time to reflect on this either. It's not like he made this known 2 weeks ago.
no,
Yeah.
I would say it was like around 11 o'clock, as a matter of fact. It wasn't even like 9 o'clock, it was like 11 o'clock.
Just a thought here. Wouldn't this be, since the potential person is actually sitting in the room, wouldn't this be best discussed in an executive session?
No, we can't.
You can't, it's not, you can only go into executive session for certain things. So it doesn't fall into any of the executive session
So-
exceptions or the,
Okay, so with that
private
said,
session
and I'll
exceptions.
get into, since you're trying to sort this out in my mind, it sort of seems somewhat unfair, and I understand we didn't used to have private sessions, but it sort of seems unfair that the individual that we're looking at can't be in the private session where we actually discuss the case and share our expertise from the different areas that we represent, but he can be in the public session. It sort of seems like we're just, okay, so he can kind of be there for part of it, but we're handcuffing him from being on the same page as everybody else. And I realize it sounds like this is new charter orders because we didn't used to have private sessions, right, Chuck?
Correct.
So now, let me just ask a secondary backup question to that. If the shoe was on somebody else's foot, like whether it be manufacturing or whether it be tenants, how would you feel as to being told, you can't come to the private session, but you can come to the public session?
I think there should be participation of both private and public. I feel like there's a comment that there is commentary that would be necessary for us to understand. I also think that jumping into the public session, having not been privy to the conversations in the private session, that would create some confusion with the discussion between the board members. So I think just for the ease of flow of information and also to gain from their expertise, I would want them to be present at the private session. And I would want that same rule for
And you would want that
I
same
would want that
courtesy
same-
extended as
exactly.
a year from now we have to do it. Chuck, if you don't mind, I'd like to have.
I take a different position. I think that, as we know, I think we're attempting to have a couple of additional meetings in June, in June and July, is that correct?
yeah, we're not going to be able to have an extra meeting in June, so it's July or nothing.
July 9th.
Yes.
There will be at least one meeting that's devoted exclusively to discussing rules. The topics that come up at Loft Board meetings include rulemaking cases and sometimes other issues. For example, I think we may be discussing the mechanics of legalization at some point. I'm going to, when we get to the minutes, raise and inquire as to what's going on with Julie's request that we discuss self-certification. I think it's appropriate for a person sitting in for one of the special interest members to participate on discussing rules. I don't think participating in cases makes sense, particularly with the public-private distinction that we've made, so I would be opposed to that.
So your,
I thought your position was different just now.
so your position is neither the public or the private?
No. With regard to cases.
With regard to cases?
Correct.
And only sit in on the
Oh, we
portion?
only do cases in private session.
No, we need to vote on them. We need to vote on them and comment them. We vote and comment.
So he would only be able to sit in on the part of the public session when we switch to the rulemaking process, correct? Is that what you're saying?
Or other topics, but he's
So
certainly,
not case topics?
but he's certainly welcome to grace the room with his presence.
Well, right, but
See, this is what bothers me about this. Now, I don't know, does the same thing apply to the rest of us?
No.
It doesn't.
The rule is only special interests.
Well, what about Mr. Hernandez, who has Mr. Hernandez?
He's a special interest.
Has he tried to invoke that?
I didn't know it existed.
Otherwise, he wouldn't.
This is something I went, oh.
Otherwise, you might have invoked that rule, or you
Yeah.
might in the future.
Exactly.
No,
I mean, as long as he's skilled.
No, he won't.
And it would also apply to Mr. Delaney.
I'm sorry.
Yes,
So-
it would.
So the board, listen, we don't want to abuse this, right? This is something that's extra, extraordinary circumstances, right? We don't want to say a member can't be here next month, so he's going to designate. What was the rule say? On extraordinary circumstances?
No,
Doesn't say nothing? We should put that in the rule. Right? So, I mean,
it just says may in their absence designate substitutes, that's what it
right,
says.
we don't want to be doing this every month, someone is out, right?
Right, I think in this
Right.
case, we know it's several months, which is why we're entertaining this idea. In other cases where it's work-related, we don't have the opportunity of being able to participate. That's on a one-off basis. I don't know that we necessarily want to go. I mean, we've already spent, 15 minutes just having this conversation.
Yeah,
We'll be doing this every single time. Let's not go ahead and take that approach. So I think in this case, we know it's a multi-meeting or multi-session, absence, so we should certainly look at this.
I just want to clarify, Chuck, you said before that you think the designee should be in the private session.
No,
Oh, you didn't?
no.
Oh, my mistake, I'm sorry.
No, I said that I was against the notion of saying, no, Carver's not here, tough luck, the owners have no representation, period. I don't think that's fair. But to Mr. Hernandez's comment, if I knew that next month I had, for work purposes, to be out of town and it was a single event, but I knew 2 weeks ahead of time, I would certainly ask the board to consider someone else to sit in my stead. But I think in that instance, the real purpose is to discuss rules and policy matters, not necessarily to participate in cases that you can't vote on.
But I mean, sometimes input is good, right? I mean, there's something that can be,
I
some.
don't have
Wait,
any
can I-
objection to it, but I have one more thing to say. We had those 2 seats held by Mr. Hernandez and Mr. Clark, vacant for the longest period of time. And I think that I had mentioned to the chair that why aren't these seats being filled? And so the fact that it went a year or a year and a half with these 2 seats not filled?
Because that's the mayor's office.
I understand, but now we seem to be invoking a rule that I never heard of.
These seats are not vacant.
And I'm not necessarily against it, but I just, this begins to sort of play out in ways that are beginning to make me uncomfortable. But I'll certainly go along.
It's still a rule.
Okay.
Yeah, just in terms of the private sessions, the purpose of the private sessions is for staff to be able to give legal advice to the board members. During the public session, if a case is coming up for a vote, the chair will ask for comments, and there will be nothing to stop the designee from making a comment unless you say they shouldn't. In which case, I think, to your point, Mr. Roche, that you will get the input from the owner rep that you might be seeking, right? So there's nothing stopping the board members in public session talking amongst themselves about cases.
Well, I'm
You
not
do
saying
that
I'm
all
more
the
I'm still
time.
trying to process the whole information. So in fact, my follow-up question is, Chuck, the historical precedents that with the gentleman that had in Australia, that was because of a death or an illness or something in the family? Not because the guy determined that he had a heavy workload?
No.
I'm a little concerned, the more that I think about this, that are we gonna, you start opening this up to a heavy workload?
We just have to follow.
We don't know why he has a heavy workload. He has a heavy
Well,
workload
but
because he
you're
has a
right.
sick cousin or sick sister in Australia, and he has to support her financially.
But
I don't
that's
want to be in
my-
the decision-making of like
But that's
determining
my
why.
point exactly, then maybe you should say that that's the reason you have, to just say that somebody has a heavy workload, I'm sure that the ladies that we have here that are in the architectural business have heavy workloads. So are we
Right, but I don't
gonna,
need to probe and understand every, I don't need need him to justify why there's a heavy workload, that's his private life. So I think in this case, what we're looking at is an extended period of time. And that's simply it. So he can either get off the board because he doesn't have the ability of being able to commit. In this case, we're not doing one-off. What we're saying is, he's saying it may be 3 months. So if it's 3 months, then let's say, okay, well, let's find an alternative time to be able to get some representation from that side onto the board. Otherwise, we're just probing into his private life. And I don't
Well, no,
think
I'm not advocating probing into
No, we
his
are.
private life. No, we're not. No, I mean, we're looking at past precedents and we're trying to determine.
But
You know,
as much as precedent is valuable, but the rule is just the rule right here, and it doesn't.
I think there's a difficult, but the rule says that the board can make the decision.
Correct. Yes, but you can't, not as to why. Right.
No, you're missing our point. Okay, you're missing my point. Any of us in here could argue that we have a heavy workload. We make that choice, okay? We make the choice, now not so much me or actually Ronaldo either, for that matter, or for the staff, but you all as individuals make the choice that you go in front of the DOI and say that you're going to commit this time and this effort on behalf of the city and that you're going to be compensated for it. To me, that has to be taken into consideration in your work life. So I'm not sure. I'm not sure that I'm convinced that workload should be a reason that we start flexing this, because I believe that that opens the door up to say that any of us can say, oh, well, you know what? I got 3 new clients. They're each paying me like $1 million. That's a heavy workload. That beats my salary that I'm making on the Loft board. So let me try to get somebody else to set it. I don't think that's the intent of what the city is trying to accomplish here.
I agree.
I
But
really
wouldn't
don't.
Yes, so for anybody, for whatever reason, if we feel that we can no longer make a commitment to the board that is required, we sort of have the moral obligation to come forward and say, I can no longer participate and I need to step down, I need to resign. But regardless of the reason, I think what we're talking about here, what it seems that we're talking about here is a temporary, or what Carter thinks is going to be a temporary situation. He doesn't feel like he's unable to make the commitment in the long term. He's only not able to make the commitment in the short term, and he's asking to invoke this rule, correct?
Yeah.
Yeah.
So that's one thing. Then the second is, I agree that representation should be full, that a full board is a more fully valued issue, rule, application, discussion, and it's helpful to have opposing sides on different issues, right? The conversations are much more interesting and informative. But then where no offense, but where I kind of pause is, so this substitute can be just anybody who's designated. So if
If the board says,
pretend
okay.
I'm a special interest, right, and I say, I don't have time next month to come, I'm sending my best friend Wendy, like, and you just have,
No, but the board has to approve it, right?
The board has to approve it, and I think in approving that, you would want to take into consideration, does that designee carry the same kind of knowledge and I guess expertise on that side and that interest, right? So that's probably something that we would consider.
is he of equal representation to the board member that is requesting, making the request? Yes? Is that what we're saying? Okay.
Yeah.
I guess as I think about this a little more, one of the things that's troubling to me is unless Mr. Carver's workload arrived this morning via FedEx, if we're grappling with something that we were confronted with all of 2 hours ago. And our tendency is to say now, oh, you want to propose a rule change, you want to do this, give us 2 weeks. And here we seem to have 2 hours. And it does appear that however we decide to accommodate this request, it's going to be in effect for a period of time that at the moment is not crystal clear. Not like I'm stuck in Hawaii and I'll be back next Tuesday and I'll see you next month. So maybe we should table this for today and consider a proper approach and put it into effect at the next meeting.
Yes, I like that idea. I also am wondering if the legal team, not the Loft Board staff, but the legal team that looks over language, I mean, you said there's no conflict,
Is our general counsel?
general counsel?
I would argue if she's presented it, it's because it's legal. I mean, it's in
Oh,
the
yeah, I mean,
rules.
No, the rules are legal, but I'm just wondering if the representative that he's picked, who represents so many of the cases that we're seeing,
Right.
if that to me seems fishy. I don't know. I mean, that's what, like, that seems like strange.
What I would assume that they would choose someone who's equivalent, who's familiar with all those cases, and likewise, you would want to choose someone who's represented tenants. I would want to choose someone who's represented manufacturers, and so that's a person who's of caliber, that merits being able to participate. Like, I don't know. I kind of
Well, yeah, it's specialized, but real estate, we have a million real estate lawyers and real estate specialists in this city. I realize that law is special to learn its idiosyncrasies and all that it involves, but I'm wondering if the primary that has the market on all the owners' client, like actively the clients of that rep are, it just seems like a conflict.
Would you have to step out every time a case comes up?
Well, step out? No, so this is simply, I mean, he's not voting.
Yeah,
He would not be voting. He would only be making a comment on a particular issue or shedding some light on the issues, but it's not making decisions.
So it
We can
seems
ignore
like
those
he's
decisions.
able to like be next to us and like,
No, I
Like
think the same way Carver does. I think the same way that Carver does, it's a comment, it's an observation that they're gonna provide, we're gonna ignore it if we don't like it. I mean, like, it's the same, and in this case, that individual has zero ability of being able to vote. So it's the same process, he's gonna sit there, he's gonna say, I believe this, and we can say, thanks, we don't really care, and your vote doesn't matter anyway, so I don't know that there is that much a challenge in having that individual there. I'd be more interested in hearing their perspective to provide and shed some light from that side, so.
I agree. I prefer that over an
Well,
empty
I
seat.
agree too, and I'm.
well, I'm not preferring an
actually
empty seat, I'm just wondering if
And actually,
there's
I
someone else.
like the fact that Mr. Carver has taken his position so much more seriously than other people that have represented the landlords. But on the other hand, this is really terribly unfair. Mr. Schechter hasn't been here
Okay,
many
I'm
times,
sorry.
and I'm sure that he's not here because he's probably working. So he doesn't
He
have
does,
that.
but he doesn't, this rule
I
does not
understand,
contemplate.
that rule
He's a
doesn't apply to
public
him.
member.
What I'm saying is, it's not fair. And I suppose I'm the oldest member of this board, and I could, give another excuse why I can't be here, but that wouldn't be allowable because the rule doesn't say it. It's also true for the fire. Is it true?
No.
See, it's not, because this is a new position. This position occurred after that ruling was initially made, right? So this whole process doesn't seem fair and right to me. But nonetheless, I will go along. I'd be
Okay.
happy to see this.
It seems like we need to modify the rules, but not now. We have the rules before us and we have the request. Yes.
Mr. Chairman, I just want to get on the record that I hold Mr. Frosch and Mr. Carver. I have the utmost respect for both of them, and I actually consider them to be good friends and associates, so this is not personal.
Absolutely.
All right.
Sure I get some-
Do we have a motion?
Well, we don't-
Do we have the 3 options?
I would say, do we have a motion to allow a designation? I would start with that. Is there a motion to allow a designation? And if that is voted yes, then we would move to the next step, which would be the extent of the participation.
Mr. Yes?
I would like to make a motion that we table this until the next meeting to give everybody time to digest it, because I agree with my esteemed colleague, Mr. Delaney, that we have something like this thrown on us at the last minute, and to try to be forced into making decisions somewhat.
I second that.
I third that.
I would prefer that we move on this now, basically because of my own
Okay, so
life, and I'm not sure I'm not going to be able to make the next two meetings. I mean, I just don't know at this point. So I would like to see it resolved today, but I'll go along with either of the...
I don't know what else we're looking at. I feel like we're stalling a decision that we all have to feel like, we do this all.
With respect, I don't think it's stalling a decision. I mean, we table cases that we have much more information on and much more time to put thought in. We table rules that we've been dealing with for years, to move on. I don't think it's...
Is it a concern of rule, is it a concern
No,
of
but I
individual?
think it's an issue here that at the 11th hour, something is sprung on the board that I didn't even know such a rule existed. And it sounds like it hasn't been exercised in many, 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 many years, so it's probably was off of numerous people's radar screen.
how is that relevant, really? Because whether or not you knew about it,
I'll tell you how
was
it's relevant. I honestly don't know how I feel about this.
But
I don't know if
But
I
you can
think-
vote no.
No, that's not the case.
Or you can vote that he doesn't participate this month, and next month, and start next month. I mean, we need to stop the deadline.
I did.
Right.
I made a motion and...
Right, it was seconded.
Okay,
Okay,
General
so-
motions to table.
So the motion is on the board. Mr. Rivera.
Mr. Byron?
Wait, what is this
The motion is
for?
to table voting on this,
The
right?
table is up to the chair. You don't make it. The chair can either table it or not table it. This is out of order.
Thank you.
Don't take a roll call on tabling
Thank you.
a purpose. So the
Thank you,
chair
Mr.
can
Barros.
either
So
table it or
my decision is not to table this motion. Not to table this vote, sorry. The matter.
Could I just, I think if you look at the existing chapter 1 of the rules, there are two provisions for tabling. One is that the decision of the chair, but I believe there's a second mechanism.
On the agenda, yeah. That's in 103. Yeah.
With all due respect, this is another prime reason why it should be tabled, because we don't even know that it can be tabled or it has to be tabled. We're actually sitting here researching this.
That's Robert's rules.
I don't think there's anything about that. In 103B, it says the order of all business and meetings shall be determined by the chair, but such order may be changed by vote of the board, and the chair will place on the agenda any matter at the request of at least 3 members, with the chair determining when such matter is to be placed on the agenda. That's the only thing that I see that even remotely goes to that. Just checking.
have another motion?
A motion that we would appoint, that we would agree that someone should become the filler in for the real estate
Designee.
rep, designee, but that we need to further elaborate.
Yeah, we're going to go after that motion, then we'll go into how much, the extent of participation.
We'll make two
But we-
motions.
But we need more time to make. I need more time. Just
All right, I second the motion.
Which one?
What motion?
The motion is that we
No, no.
approve the designee. Isn't that what you said?
Not approved,
But
but-
not right now.
but not now.
I didn't get your right to look at it, say it again.
In concept, I agree there should be someone appointed. I'm just not ready to appoint someone because we were thrown this at the last minute and I'd like to get to the cases. So how can I word that into a motion?
And that's the same thing
I think
that you're
that's-
asking to be set
That's
aside.
the same thing, and
That's
that's
the same thing as
I asked.
What is your motion, Mr. Bowers?
we could make such a motion to hold it off. And in the sense of rule, the chair, I think we can, but I'm not exactly sure about Robert's rules in this particular case.
And where's the reference to Robert's rules in chapter 1?
103.
Could you read that, please?
Sorry. All meetings and hearings will be conducted in accordance with Robert's Rules of Order unless such rules are in conflict with anything stated herein, in which case these regulations shall control.
Right, and I don't believe anywhere it's stated in the regulations that only the chair can table something. And I think that a motion to table was properly made and seconded. And I don't think it's disallowable.
I don't think that's correct, but anyway. See, I think that there is one particular Robert's rule which we don't follow. And that is because we have to make our votes public. But generally in Robert's rules, if any member of the board wants a secret ballot, it's automatic. You don't have to vote on it. But in this case, we can't do that because the votes have to be made public. So we can't invoke a secret ballot. But in normal cases, you need one out of whether it's 5 people on the board or 50. Asking for a secret ballot, it's automatic. There are some things about Robert's rules that just seem to fall into place. This is one. Now, if I'm wrong, I don't know, I'll go look again, but I don't think I'm wrong.
But again, with all due respect, we don't know that you're right, and we don't have that information here in front of us, so that to me is all the more reason that it should be tabled until we do have those facts.
Elaine is curious this time to get an answer.
Completely.
Yeah. Can we take a photo?
Well, Julie's motion hasn't been seconded, so maybe we can have another motion that we can get a second. And I would tend to agree with the executive director saying we should have a vote whether or not the designee can participate without getting into the specifics of the participation. And then go on from there, either.
A
the next
designee
meeting-
or the designee? Just a designee.
Well, we don't have to vote on a designee. That is already the rule. That a designee can. So we have to vote on the designee.
The
Correct? Right.
Are you making a motion, Ellen?
Right.
I'll make a
Right.
motion.
I mean, the rule says it's allowed, and then the board has to accept it.
Wait,
It
Yes.
looks like there can be a motion to table, what I'm reading.
Reading where?
Google Robert's rules.
Oh.
Sorry.
Make sure it's the right one, it's not Google's version.
honestly,
All right.
Mr. Chairman, with all due respect,
Yes, sir.
we don't have the answer on the Robert's rules. We have no one that's sitting here willing to state with all certainty, and now we have our executive director saying that she thinks it can be. Please take the appropriate measures here and go along with all the facts that are being presented, which are, we don't have the facts.
Okay.
This is Robert's Rules of Order online, which is a little better than just the Google version. So I have to say, to me, this is virtually incomprehensible. I'm sorry. I mean, I can read you just the first sentence. This motion takes precedence of all other subsidiary motions and of such incidental questions as are pending at the time it is made. It yields to privileged motions, and such motions are incidental to itself.
Okay. That means the chair has the final say.
I don't know.
I think it means that under Robert's rules, a member of a body can make a motion to table if it's seconded and adopted, and I believe it's supposed to be undebatable. And when adopted, that shuts down the
Why would it
discussion.
be undebatable?
Well, it's debatable, but I disagree. Sorry. But anyway,
Okay.
you know, I doubt my own existence, so I can be wrong.
None of us thought we were going to be confronting this today, right?
Right.
This is not what we're prepared to do here today.
Okay. What was the motion? The table.
Table Mr. Robert's request.
Could you please make the motion? Who made it?
You can make a motion.
No, I can't. That I
Chair
know.
can't make a
I cannot
motion.
make
Oh.
it.
Mr. Roche made his motion.
Who was it again?
Mr. Roche.
Oh, Mr. Roche, could you please make the motion? We'll vote on it.
I make a motion that we table this matter until the next meeting, at which time we should come back prepared.
And I'm seconding that.
Mr. Rivera.
Mr. Roberts.
I vote present.
Just write down present.
Mr. Brooks,
Yes.
Mr. Hernandez.
I want to say fine, but yes.
Ms. Torres.
Yes, I'm voting to table it.
Mr. Delaney.
Yes.
Ms. Roseman.
I'm going to vote no. We should vote.
Chairperson.
No.
Is one present. 4 in favor, 2 against.
So now it didn't
You
pass.
didn't.
So it's not tabled. So it didn't pass.
Discussion,
You need
does it
another-
even matter? Do we have to vote on something being that it's a discussion or?
Oh, you have to make a decision as to whether or not we should have a designee, who that designee should be, in the scope of that. So the motion was to not deal with that today. That didn't pass, which leaves us with dealing with it today.
When you say that, I'm fine to vote whether or not we need a designee, we do. But I'm not
So
ready
then
to
make a
vote
motion.
on who that designee is. So what's,
So we're not going to postpone it because that failed, so we need a motion. Different motion.
We'll make a motion to.
No, really, that's not the question, who it is. We know who it is. And I think we should proceed with, and I agree with Eileen, we should proceed with one motion, whether or not we will allow a designee. And then we can get into specifics or not.
Thank you.
I make the motion as to whether we will vote tomorrow.
I second Mr. Fernandez.
Thank you, Mr.
Good. The motion is to allow a designee. So we know
I'm
clear yes
sorry.
or no.
Yes, I'm sorry. So wait a minute. Is it a designee or the designee?
A designee.
No.
Whether we want, we can do the designee.
The designee.
The rule says,
The rule says you're allowed to have a designee.
so we don't need to vote on that.
So
because it
we are
exists,
voting,
right?
the board is voting to accept that designee. Excuse me, whether or not they will allow the designee, yes. So it's not a designee because we're not going to go
The designee.
the designee.
Because
Yeah.
the way that the rule, I'm sorry, the way that the rule reads, it says that the special interest person gets to name who the designee is. That's the way that the rule is phrased, right? So the special interest holder may designate a substitute. So that authority is vested in in the special interest person, which makes sense because they would be
So
the best
therefore, the
decision.
question is, do we accept Jason Frosch as the designee of Mr. Carver to participate in some manner, shape, or form to be
Right.
determined?
That's the, we should phrase it that way. Make it clear?
Yeah.
We can have a second motion.
The motion.
This one has been seconded, so we have to,
Mr. Listen, the person who made the motion is going to restate it.
Yeah, so the motion is that whether we designate David Frosch as a representative for the,
Jason.
Jason, I'm sorry, for the landlord, special interest position.
For any term or?
No,
just like
for the request he's made for the,
Just like forever? you
no.
could-
What was the request? This month?
The request was for this month, and I asked him, does he want that to continue, and his answer was it should be continuing. But I believe it will be before
could we-
June, July, and
So in
August.
the next,
Could we
in
do one
the
I've
next,
heard
next week and
May,
then
June, and July.
extend it?
in the next discussion that we're going to have is the limitation, right? So that's where we left off.
Or we could do one for next week.
Could we do one for next week and then just next week make a quick decision, next month, sorry, and then make a decision as to whether to extend it for a longer period of time? At least that would be done, at least, yeah. So let's do it for next month, and then we can make a decision as to whether we extend, a quick decision.
But the extended discussion, could we put time in it too, timeline? Like, can you say 2 months, 3 months?
Oh, yeah.
yeah, well, the thing is, Robertson, you should really withdraw your first motion because you can't have two different motions on the floor at the same time. That your first motion was second, so you really have to withdraw it. So let's say you've done it, and then make the second motion.
Right.
Just withdraw your first motion.
I didn't pick I didn't pick a time, yeah.
You were just
You're just saying, why to simplify things? Why don't you amend your motion to say for this meeting, you move that we accept Mr. Carver's designation for Mr. Frosch?
I amend for this meeting, we move to accept Mr. Frosch as Carver's representative.
A second.
Mr. Rivera?
Mr. Bowers?
Yes.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Ms. Torres?
Yes.
Mr. Delaney?
Yes.
Ms. Roseman?
Yes.
Chairperson Hudson?
Yes.
7 in favor.
Thank you. Now we have to go on to the next discussion, right?
As to the
As
extent.
to the extent of Mr. Frosch's.
Yeah, I just gotta say, the rules are going south today, that's one thing.
Yeah, there's no question about that.
Okay. The floor is open.
I apologize. What did
So,
So basically is he going to get to comment on cases and do rules? Or just cases, or just rules? Those are your choices, so.
Private session, no
Just
private
for
session.
today.
Well, today we already had the private session.
Good.
So,
Excellent
That's
point.
what?
clearly not,
excellent
not a
discussion.
private session today.
Excellent point.
But it's just for today.
It's just for today.
Not even doing rules.
I don't think we're going to get to rules.
Yeah, let's hurry up and get to our cases.
the board meeting ends at 6 today.
Okay, so,
Somebody has.
So, I mean, do we have the floor? I mean, does anyone have any objections to Mr. Frosch then commenting on cases?
That are not his.
Yeah, well,
That are not his
We need a motion. I'll make a motion to
No, just one other
allow
question.
Mr. Frosch to comment on.
It's, whatever it may be, since I am not sure about this, whether Mr. Frosch has looked over the orders or not. If he has not looked over the orders, it's just impossible for him to discuss them in any manner whatsoever.
And then he won't have any comments.
So we could, I would be perfectly happy for Mr. whoever the designee is, Mr. Frosch, to come and sit here. But certainly he can't,
Well,
I mean, what does he would go look over this thing?
well, maybe if he's a speed reader, yeah, and he can do that, fine. I mean, that's not our concern.
I mean, the staff will be making presentations in some of the cases.
Okay, do we have a motion?
Okay, yes, that was a motion.
The motion was that,
The motion was that Mr. Frosch can participate in discussions regarding cases before us today.
okay, and if we ever get to rules, should we make one?
Rules for today? Are we
Today.
doing rules today?
It's very possible.
Yes, we might.
Oh, and if we get to rules today, then yes, rules too.
Is there a second on that motion that Mr. Frosch, okay, good. I just want to make sure the motion is clear that Mr. Frosch would participate in discussion of cases,
Not his own.
not his, yes, listen, not his own, not involving anything that may present a conflict, and also rules if we get to it today.
Mr. Bowers?
Yes.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Ms. Torres?
Yes, but I'll just say I'm not
But-
very happy with the conflict of interest here. But
Okay, Mrs. Delaney?
No.
Ms. Rosen?
Yes.
Jefferson?
Yes.
6 in favor, and 1 against.
Oh, can I change my vote to no?
You did vote no.
Yes.
So 5?
I'll allow it. It's in the same breath. She's changing her vote to no.
Okay, so 5 in favor, 2 against.
Motion is passed. So is this where we invite Mr. Frosch?
I guess so.
This is the
Do we have a set of cases?
I just want to say, I know Mr. Carter didn't mean to spring this on anyone, and I know you would appreciate it that you put this much thought and attention into it, so thank you. It's much appreciated.
Jason, may I ask you a question? Do you have any thoughts on what would be the appropriate?
Please finish your sentence.
What would be the appropriate way to seat someone under this kind of circumstances? I'm asking because I'm genuinely curious.
Having also only thought about it since this morning,
Fair enough.
yeah, I think you should give as much leeway to the members as you feel comfortable to do this kind of thing, given that they're not just representing the public, which is what the other members, other than special interest members, are doing here, and there's several of them. They're really the only person on the board who's representing that particular interest, and it's more important, I think, that you give some flexibility to that particular individual rather than risk excluding that interest from the discussion.
You got everything?
Oh, yes.
Well, while we're on the subject and not just getting the story away, I have to get my mind to understand. So now, next month, we're going to
Do this again.
do the exact same thing.
So hopefully he does a good job today.
Except then if
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 Mr.
we-
Carver so requests.
But if we go through this again next month, then it only occurs during public session again. So there's no time that
Exactly, because
we
he'd have to be.
ever invite Mr. Frosch to private session? Or
Well,
do we have
not the
to-
way we voted, because by next month's debate on this,
Right,
it'll
it's
be
already past
passed.
private. That was my point.
So that may be a default. Just the way it is.
You know, the legislature screws up all the time. I just want you to know.
So if this goes well, then can we change our invitation for like next month for the next month?
You could do that anytime before the meeting ends. All right. Minutes. Script. I got a script. I'm sure everybody read through the minutes. We now turn our attention to the vote on the minutes for the March 21st, 2019 public meeting. Are there any corrections or comments on these minutes? Mr. Delaney.
Sorry to,
That's right.
Okay.
the good news is I don't have any comments on the April minutes.
Okay.
Unfortunately, we're talking about the March minutes. Number one, they're not on the website.
Yeah, what's that?
Really?
Yep, they're not on the website. The reason I know this is because it says that we have something that's attached to the minutes, and I thought it's not attached to here. Is it on the website? And in fact, these minutes are not on the website. It jumps from the early March meeting to April.
Somebody verify that? Okay, well, I'll
Because
verify
Rivera
that.
is looking into that.
Okay. So if it's not there, are we able to vote on it?
Yeah,
Okay.
they had it. I mean,
All right. Are there any comments while we were doing that? Are there any comments on the March minutes?
Well, I've got a few more.
Yes.
The question on page 4 about self-certification, I wonder if the board and staff has had the opportunity to give that any thought and whether that's going to become a topic for discussion as Julie requested.
You know what I'll say there? I'll submit a formal letter today.
Okay. I do have, I actually came prepared a little bit with Julie, and I'm sure you guys would know about Buildings Bulletin 2016-10-10. That's talk about Operation Policy and Procedure Notice. It supersedes that one of 1004, and that's to do with the establishing procedures for professional certification program, which allows a professional engineer or registered architect as an applicant to certify the job compliance with New York City construction codes. I have that handout to the board, and I think that should be digested a little bit to see if you answers any questions. I think one of the requests was that someone make a presentation before the board. Is that was one of the things that from what I understand, that DOB come and talk to the board. I think it was your idea.
Yeah.
That someone from DOB come and talk to the board about that process. So if you don't mind, I can just hand this particular procedure out so that everybody understands it, the department's procedure, and then if that doesn't satisfy, then we'll revisit the whole thing about having a presentation for the board to discuss this. Is that all right? And then, Torres, I believe you had a request that you're going to put in regarding particular audits, right? Jobs. So I'm just going to pass it in either direction. Please take one and read it. That's also on the website. On the DOB website. The DOB website. Yes.
One thing on the minutes, first page, very minor thing, but in Roach at the very bottom.
Mr. Roach.
Extreme-
Sorry.
It's extreme.
It was
People would have figured it out. Top of page 6, first line, Mr. Hilton says there's 6 cases on the summary calendar. There were only 5.
Did we table one?
Table.
No, if you look, there were only 5.
Yep.
Okay, I apologize. Did I say that then, or did I say 5?
I don't know, but there were 5, so we'll make it.
We'll make it.
It's okay.
If I said 6, that's technically.
No, it's good. No, it's 3, 4, 5.
Any other questions, comments?
Yes, I have one more.
Yes.
In this meeting, we seem to be wavering a bit in terms of what we're recording in terms of cases. In prior minutes, for example, the January minutes, the master calendar cases included the conclusion of the order.
Oh, you're right, I forgot.
And in these minutes, there are no conclusions.
Okay, we'll add that. Sorry. Yeah, I guess we should.
Let's table the reading of that, of the March 21st minutes.
I gotta read it again.
Just read the conclusion.
Is there anything else that needs to be fixed?
Yes, do you have anything else?
Does anybody have anything
I
else?
have one more. Page 22. Right at the bottom, Ms. Paulson says, right, they're gone. They moved down, they never one was. I think it was, they never was.
Was one, yeah. Yeah.
All right. I think there was something else that I saw, lawsuit, the word lawsuit was probably supposed to be one word. It's in there somewhere. All right, it's going to be tabled. We now turn to the vote of the minutes from the April 18th public meeting. Are there any corrections or comments on those minutes?
I would just comment that these were very good minutes. An excellent job.
Thank you, Ms. Ryan.
Is that it?
Motion to
All right. Do I have then a motion to accept?
accept.
A motion to accept the start. A second. Mr. Roberts. Mr. Rivera.
Mr. Roberts.
Yes.
Mr. Roach.
Yes.
Mr. Hernandez.
Abstain.
Mr. Delaney.
Yes.
Ms. Torres.
Yes.
Ms. Rockland.
Yes.
Chairperson Hudson.
Yes.
6 in favor, 1 abstaining, 1 absent.
Okay, so since I can make a comment after this, right? I just want to say, especially in a lot of meetings, the minutes are not, attention is not paid, proper attention not paid to the accuracy of these minutes, and I want to commend the board, and especially Mr. Delaney, in terms of taking the time to go over these and make sure we have accurate minutes, so kudos. Okay, Ms. Paulson will now give her executive direction.
So the first thing is that in terms of proposed amendments to the Loft law, the Assembly yesterday passed amendments. There was also a bill introduced in the Senate, but the Senate is split. So I've been checking my phone to see whether I'm waiting to hear back from state legislative affairs folks as to whether or not anything's moving, and I haven't heard from them. So I think that's very exciting that we have a bill that's moving, and we'll see what happens.
Can you please summarize the amendments that, since it's been,
Yes.
there's been a lot of discussion.
I can. This is the bill,
For
this is
for clarity.
Yes, this is what I believe is in the bill that the Assembly passed. The bill clarifies that only the unit seeking coverage needs to meet the eligibility requirements, not 3 units. It eliminates basement window and use group 15 through 17 exclusions. It excludes buildings in the North Brooklyn IBZ M3 zones. It shifts the burden of proof on incompatible use, which would now be only use group 18, to the party opposing coverage, and that use must exist on the effective date of the amendment and continue until the time of the coverage application, be in legal operation and create an actual risk of harm which cannot be reasonably mitigated. It adds a new window period, a section 281-6, which would be one from January 1st, 2015 through December 31st, 2016. It would be, with the exception of West Chelsea, 3 families living independently, and that occupancy has to be continuous for 12 months during those 24 months. It keeps the West Chelsea requirement for just 2 families, It raises the maximum penalty for loft board violations to $25,000. It gives the law department the power to bring a civil proceeding to enjoin violations of the law. It deletes the statute of limitations for filing coverage and registration applications. It adds code compliance deadlines for the units covered under the new amendments. And it allows for previously litigated claims to be refiled if the building or units would be subject to the loft law as a result of the amendments. In a nutshell. Next thing in my report is, I just wanted to note that last week Martha and I attended a meeting of the Land Use Committee of Brooklyn's Community Board. One, we found it very informative, and I hope that we communicated some useful information to those folks. In terms of staffing, the Loft Board now has a new HPD inspector. His name is Dewan Tariq, and HPD has also designated an alternate inspector, Kashif Raham, they're both here today, to fill in if Inspector Tariq is unavailable. And we will have, hopefully by next month, 2 legal interns, and then in July we're going to have a college student that will be working over the summer. In terms of revenue, we collected $9,326.75 in April, that's unofficial, and the bills for fiscal year 2020 should be mailed out in early June for the registrations. In litigation, I already distributed to you, but I also had Ms. Rivera give you hard copies. We got a favorable decision in a case, Barrett Japanning versus Loft Board and Anna Villalobroda. The court dismissed the Article 78 petition against the Loft Board and granted Ms. Villalobroda's motion for summary judgment. The board had awarded coverage to the building and protection to Ms. Villalobroda. The owner attempted to file for reconsideration, but the owner's reconsideration application was incomplete and untimely. The court agreed with the Loft Board, and I have to say I was particularly pleased with this language. The court stated it could not fathom how it would be unreasonable or irrational for the Loft Board to insist on strict adherence to its timing and filing rules. The court also rejected the owner's argument that the board's decision was not supported by substantial evidence, finding that the board considered the full contents of owner's reconsideration application, and owner has appealed that decision. In a very interesting case, which was filed by some tenants on West 45th Street, these were a group of tenants. The owner had changed the entry locks to an electronic system with swipe cards or a phone app, and the tenants objected to that. They wanted mechanical keys, so they sued in housing court. There was a lot of back and forth. It got a lot of play in the press as well. That case has settled. The owner has given the tenants mechanical keys in exchange for their promise to never, ever use the electronic system. And the last 2 cases are mandamus proceedings, Brocha V'Hatzlocho Corp. Versus the Loft Board, and 110 Bridge Street Realty Corp. Versus the Loft Board. These are both cases that came to us from Oath involving incompatible uses, and the issue in both cases is whether there are inherently incompatible uses in the buildings. So,
What's the first case?
Bracha V'Hatzlocho Corp.
Got an address? Got an address for that?
I don't, but perhaps Mr. Frosch does.
Well, I can tell you it's Brocha is my best approximation of that.
Very
and
nice.
that is 538 Johnson / 75 Stewart Avenue.
538 Johnson.
Is that your case?
Yes.
Yeah, well, that's filed by Brocha, yes.
That'd be good if you could mention that one in the case.
Sure, absolutely.
That's it. I'm sorry, that's the end of my report. If anybody has questions.
I have one question. And apropos of your mentioning interns and a college student, I actually received a request for a copy of the retroactivity memo that was written last summer by Tyshawn Raffington, I believe.
Trishan, yeah.
Trishan Raffington. So my question is, yeah, these loft tenants, they're on the ball. That's all I can tell you. Is that a public document?
That's a good question. would have to read it again and see whether or not we presented it in public at a board meeting. Certainly, if it was given to you at a board meeting, then it would be a public document.
That's where I got it.
Then I guess,
We discussed it.
I think she did. I think she did. Why don't they just,
What she presented.
they could foil it. So let them, please
No.
tell whoever inquired to make a FOIL request, and we will do it.
No, my question is it a public document?
I have to look at it, but I think if it was presented at a board meeting, it's a public
I'll
document.
be happy, unlike the last question that was unexpected, that we spent a lot of time on, I'll be happy to get a response via email.
Okay.
But my question to you is it a public document?
I think it's not a public document to the extent that it was published or something, but most government stuff is public if it's FOIL. So
Well,
it can't be
but
FOIL, except for the, these categories of,
Well, if somebody wants it that badly and it's a public document, I'm going to sell it to them rather than tell them to foil it.
No, you won't.
So you'll let me know.
Yes, I'll let you know.
I guess I have a comment on the bill language. Maybe we could quickly talk about that. I think it goes pretty much without saying that from an owner's point of view, changing the law to no longer require a window in a unit to further restrict the definition of a hazardous incompatible use that shouldn't be in a building that's covered. Those are probably two of the worst aspects from an owner's perspective, again, that's in this bill. And I'm just curious if there's any perspective from the architects on the board, the fire department on the board, or the tenants representative on the board about those issues, given that this is still the opportunity for
We already went over, are you going back to her announcement?
Well, he's making a comment on my report before we move on to the next agenda item, which he's allowed to do.
Yeah, I just wanted to put in my 2 cents from the owner perspective on that bill language, and just, there just hadn't been a comment about that first item that Director Balsam mentioned, so I was inviting any discussion that the board members might want to have about that.
No discussion.
From any, no one else wants to have that discussion, I gather.
I would like to have some discussion on that,
Okay.
but
Could we have the discussion after cases? I want to make sure we get, we got,
yeah, I'm flexible, but if the fire department does have a perspective on that, if we're going to open a window for that perspective to be shared.
my only concern is that we're going to get kicked out of this room. That is my only concern.
I would be happy to say let's do it after cases only, but for the fact that if we don't end up doing it, this is something that may be moved by the next meeting. So if there's an opportunity to talk about the concerns.
We're not rating the bill, so I'd rather stick to the cases that the public is here for.
Well, I think that the tenants and the owners and the manufacturing interests that are affected by the Loft law are participating in the lawmaking process. So at least with respect to those interests, it is important.
We'll consider just after the cases.
Understood. Thank you.
All right.
Mr. Chair,
Yes, sir.
can I take 1 minute to review? I've attended several meetings of the rezoning of Soho and NoHo, and a couple of private sessions where an exclusive number of people have shown up. I just want to say that the one thing is that most of the people in the city, the planners, most of the residents, most of the business owners, most of the landlords in Soho NoHo have no idea what the Loft Board does. And I just found it really very perplexing that somehow we must be able to get some information out so people in the city could understand what our purpose is.
Okay, great. And I think that will happen when the law gets.
Okay.
Great. So that was Ms. Balsam's report. No comments. No other comments. We'll turn now to appeals and reconsideration calendar. There's one case on that calendar. Ms. Balsam will present Laura Dabrowski, Mayor, and Jeffrey Mayer, Charles and Cynthia Broderson at 873 Broadway, also known as 15-25 East 18th Street, Manhattan. Docket numbers R0365 and R0367.
On March 15, 2018, the board granted the owner's request for removal from the Loft Board's jurisdiction. In its order, the board set the initial legal regulated rent for Unit 700 at $1,949.68. For Unit 603, the board found that because the owner had purchased the tenant's rights for the unit under MDL 28612, although the tenants remained in occupancy, the board did not set an initial legal regulated rent for that unit. Subsequent to issuance of the order, the tenants in both units filed requests for reconsideration. In addition, the tenants in Unit 700 filed 2 amended applications, and the owner filed 1 amended answer. As to the amended applications, the owner argued, among other things, that the Loft Board should reject them because they were filed after the 30-day deadline for filing a reconsideration application, and accepting the amended applications would render the deadline moot. The tenant counter-argued that the reconsideration rule is silent on the issue of amendments to applications. However, the reconsideration rule states that, except as otherwise stated therein, the procedures in 29 RCNY 1-06 apply, and 29 RCNY 1-06 allows for the filing of amended applications. The proposed order agrees with the tenants and states that since the reconsideration rule, 29 RCNY 1-07, is silent as to amendments, the procedures in 29 RCNY 1-06 control, and amended reconsideration applications should be considered. However, the proposed order also cautions that an amended reconsideration application may not be used to supplement the record unless the additional documentation meets the standards for acceptance pursuant to the reconsideration rule, which would be relevant probative evidence that could not have been discovered at the time of the hearing despite the exercise of due diligence. As to the merits of the claims, for Unit 700, the tenants, Mayors, claimed that they were denied due process for several reasons, including that the initial legal regulated rent was miscalculated. In the original order, the board calculated the code compliance increases as 6% for filing an alteration application, 8% for obtaining a permit, and 6% for achieving compliance with MDL Article 7B. The tenants argue that the board should not have compounded the increase. Instead, the tenants state the board should have aggregated the increases and added 20% to the base rent. The proposed order finds that the tenants are partially correct. Multiple dwelling law section 286(2)(ii)(e) states that an owner who obtained an alteration permit prior to June 21st, 1992, which is the case here, is entitled to a prospective increase of 14%. Only if owner had achieved compliance with Article 7B prior to June 21st, 1992, would owner be entitled to a prospective increase of 20%. However, here, the owner achieved compliance with Article 7B in February of 1994, which is after the June 1992 cutoff date. Based on these new figures, the proposed order sets the initial legal regulated rent for Unit 700 as $1,941.49. The proposed order also finds tenants' additional claims are without merit. As to Unit 603, the owner argues that pursuant to a stipulation of settlement resolving separate court proceedings, the tenant, Mr. Brodesson, sold his rights to the unit. Mr. Brodesson claims he did not sell the owner his Article 7C rights for Unit 603. He claims he only sold rights to Unit 612-613, which are other units the board had previously found were part of one large IMD. The proposed order agrees with owner. Plain language in the stipulation undermines the tenant's claim. In the stipulation, the tenant agrees that, among other things, he has sold all of the rights to rent regulation that he could have had in the building pursuant to MDL 286-12.
Thank you, Ms. Balsam. Is there a motion to accept this case?
Perhaps we could have just a brief comment on it.
1 second. We got to accept the case.
Oh.
Motion by Mr. Hernandez. Is it second? Mr. Roche. Ms. Rivera. Wait, I'm sorry. Is there any comments on this?
Yes. From an owner perspective, I don't think there's an issue in terms of, the majority of this case was math. The only thing that concerns me about it is there seems to be a very limited holding here that amending a reconsideration application, in this case several times, was in theory permitted, although here it's also noted that adding additional documentation wouldn't be permitted. The only reason I have a concern there is this was filed in May of 2018. The first amendment was filed by the Myers in August 2018, just 2.5 months later. Another one was filed a month later in September 2018. And my main concern there is that doing this and allowing this, at least in certain limited circumstances, can significantly delay a reconsideration being heard by the law board and processed by the staff, because it can just keep getting amended, and continue to push the process out. So that's my concern, that this really doesn't constrain that practice strongly enough, and I'm worried it could be abused.
So I had a similar question when we were, it was clearer here in your presentation than it was earlier in the private session, right? So there's a point, because this could be for the owner, could go anyone who's making a reconsideration, so it's both sides. Just, so an amendment application is filed, they have 30, the applicant has 30 days from the decision to file the amendment, is that correct?
You don't answer questions in public session.
Oh,
You only answer in a private session, I'm sorry.
I'll answer. I think that's correct.
Okay, but then there is a cutoff point at some, there has to be some cutoff point.
That I want to answer.
Okay, we'll talk about it more next time.
Any other comments? Ms. Rivera?
Mr. Roberts?
Abstain.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mr. Guerini?
No.
Ms. Torres?
Yes.
Ms. Roseman?
Yes.
Chairperson Hudson?
Yeah.
5 in favor, 1 abstain, 1 absent, 1 no.
Mr. Hernandez. Thank you, Ms. Rivera. There are 3 cases on the summer calendar. They're voted on as a group. One of these cases, number 2, Amy Franco, will be tabled today. So that docket number,
No.
no, it's not being
No,
tabled.
it's fine. Amy Franco is the next one.
Amy Franco
You just
is,
had to address.
Oh, it's 18th Street.
I know, but the case is under the address. Protected document.
We're tabling case number 3, tenants of 255 18th Street at 255 18th Street, Brooklyn, TM0091. That case is being tabled. The other 2 summer cases on the summer calendar are Amy Franco, 8 through 10 Grand Avenue in Brooklyn. Docket numbers PO0088 and TA0253. And case number 4, tenants of 178 Walworth Street. Address is 178 Walworth Street in Brooklyn. Docket number TN0225. Is there a motion to accept these cases? Mr. Borowitz, is there a second? Mr. Hernandez. Mr. Rivera, any comments? Any comments on these cases? No comments. Mr. Rivera, please pull the board members.
Mr. Roberts?
Yes.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mr. Guerini?
Yes.
Ms. Torres?
Yes.
Ms. Roseman?
Yes.
Chairperson Hudson?
Yes.
7 in favor, 1 absent.
Thank you, Mr. Rivera. There are 3 cases. There are 3 cases on the master calendar. One was, there are 3 cases on the master calendar. The first case is applicants Gregory Busted and Katerina Pablotsky at 57 Thames Street in Brooklyn. Docket number TA0228. And Mr. Clark will present this case.
Thank you, Chairperson Hilton, and board members. On September 15, 2016, tenants of Unit 4N of the building filed an application alleging overcharge in rent. Tenants also sought to recoup payments made for the security deposit of $5,150 and an administration fee of $750 paid at the time of leasing the unit. On October 18, 2016, net lessee filed an answer. The ALJ's report recommends the Loft Board grant tenants application in the amount of $10,160 for overpayments related to rent paid beginning June 1st, 2014 through September 31st, 2015, and denied tenants' request to recoup the payments for the administration fee and the security deposit. MDL Section 286-2I and 29 RCNY Section 2-06.2A4I states that a residential occupant entitled to protection shall pay the same rent accepted and paid on June 21st, 2010. The net lessee does not dispute that the rent, including a water charge on June 21st, 2010 was $1,975, and that tenants paid $2,610 monthly between June 2014 and September 2015. The record also establishes that tenants prepaid the last month's rent at the same rate. The only limitations on overcharges and awards in the Loft Board's rules are contained in Section 1-06.1C. Pursuant to the rule, overcharges shall not be awarded for the period prior to the date of filing a coverage application or a registration application. This limitation does not apply here because net lessee filed a coverage application in March 2014 prior to tenant's occupancy in June 2014. Therefore, the proposed order before you states tenants may collect overcharges since the beginning of their tenancy in June 2014. The difference between tenants' monthly payment of $2,610 and the legal rent of $1,975 is $635. Tenants paid this excess amount for 16 months from June 1st, 2014 to September 31st, 2015 for a total of $10,160. Tenants are also entitled to the overpayment of $635 related to the payment of the last month's rent, as it is directly related to the rent for a grand total of $10,795. Finally, tenants are not entitled to recoup the security deposit or the administration fee, as they are not rent, and nothing in Article 7C or the Loft Board rules govern security deposits or administration fees.
Thank you, Mr. Clark. Is there have a motion to accept this case? Mr. Roche. A second. Mr. Delaney. Any discussion on this case?
So I'm only going to note that I was obviously, I think if you see at the end of this, the attorney for the owner on this case. I no longer represent a party. To the extent that I think there are certain principles in this case that could have an effect in a more general context, a part of me wishes I could comment on it, but I'm going to respect whatever the wishes of the board are, obviously, on continuing.
I think it's best you not comment.
Yeah, understood.
Thank you. Any other comments?
Yes, I would just note for the record that I raised the issue in the private session that in this case the report and recommendation was issued in August of 2017, so that's about a year and 3/4 ago. I was contacted by the applicant about 6 months ago asking why this was taking so long. And particularly given that there wasn't a lot of extensive analysis and the board agreed with the both judges' recommendation, perhaps in an overcharge case we should look toward expediting the procedure a little bit the way we do with access and with harassment cases.
Any other comments? Rivera, could you please pull the board members?
Mr. Roberts?
Yes.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mr. Delino?
Yes.
Ms. Torres?
Yes.
Ms. Roseman?
Yes.
Chairperson Hudson?
Yeah.
7 in favor, 1 absent.
Mr. Clark, thank you. The second case on the master calendar is the matter of 224 through 228 North 7th Street, Tennis. That address is 224 through 228 North 7th Street, Brooklyn, and that docket number is TR1143. Mr. Bell will present this case.
Board members, the tenants of 5 units in 224-228 North 7th Street, located in Brooklyn, filed a coverage application seeking coverage for units F, G, 1, A, and B. A one-day hearing was held on September 3rd, 2015, regarding whether units A and B have at least one window in each unit that opens onto a lawful yard for coverage under MPL 281 subsection 5. There was no dispute regarding units F, G, and 1. Owner agreed it would register units F, G, and 1 as INDs and the tenants of those units as protected occupants. In opposition to the application for units A and B, owner argued that the windows in units A and B each do not satisfy the window requirements in MPL 281 subsection 5 because the windows are lot line windows that do not open to a yard or court on the same zoning lot, and the windows do not open and therefore do not meet the legalization standards for light, ventilation, and air under Article 7B. In prior cases, the Loft Court rejected these arguments. In matter of Doris, the Loft Court held that the lawful yard does not have to be located partially or entirely on the same zoning lot as the unit at issue. In matter of Schuss, the Loft Court held that for a finding of coverage, the window at issue does not have to meet the legalization standards for light, ventilation, and air. And again, in Doris, the Loft Court also found that the accessibility to a lawful yard or court is not a prerequisite for a determination of coverage. Judge Richard recommended coverage based on the windows facing the rear yards of residential buildings. The proposed order before you accepts Judge Richard's recommendation that units A and B are INDs each with one window satisfying the eligibility requirements under MBL 281.5 and rejects her analysis regarding the skylights as unnecessary.
Thank you. Is there a motion to accept this case, Mr. Delaney? Is there a second? Mr. Hernandez. Do we have comments on this, please?
Yes. Okay, so this is a matter of Doris case. and this is-
Wait, do you represent either side?
I don't. I've never been involved in this case, but I'm very much aware of it because it's one of the earlier cases that extended matter of Doris. So matter of Doris is infamous amongst practitioners of the loft law because it, for the first time, held that normally when you have a window that's on the lot line, it is not permitted to use it for light and air purposes with certain exceptions. And it's very difficult, if not sometimes impossible, to legalize depending on what's going on the lot on the other side of the lot line. And matter of Doris was a case that the Loft Court adopted for the first time, saying that even if you have a lot line window, which had previously been viewed by the experts, I'm not sure if there had been an actual decision on the matter, as not qualifying under the window requirement for 281.5, instead, if you have a lot line window, but what's on the other side of the lot line is a yard or court that is legal with respect to the building or structure on that lot, then it satisfies the language of the statute, which is a very creative and interesting legal argument to make. The problem with it from a practical point of view is the owner doesn't have any control in most circumstances of the I&D building of what the owner of the building on that lot is doing with that open space. And it may be open at the time of trial, and it may be that by the time the law board votes on it, the owner has decided to construct something that blocks whatever open space may have been there at the time of the hearing. So if that happens, or if the owner proceeds with the obligation to legalize the unit that's covered with a matter of doors theory, how, and I am particularly asking this question of the architects on the board, how can an owner get through the legalization process, providing light and air in a unit where the only exterior facade that the unit has is this lot line? How can they get proper light and air other than through having to purchase an easement from the neighboring owner? And what if that neighboring owner just doesn't want to sell an easement? So that's really the big concern of finding coverage for two units that don't have anything but a lot of language.
It's good. So earlier, this case gave me pause for some of the same reasons. And the answer is you cannot, that particular window cannot be considered legal unless you get an easement or have a zoning law merger. The discussion was that this is just a coverage application, and so there are various ways to legalize a unit just because it's not, in its current state, not legal in terms of light and air or egress or occupancy. That doesn't mean it can't be made legal, which I get. I feel this logic puts the cart a little bit before the horse, because then you're granting coverage to someone to whom you then may have to withdraw it at a later date if there is no viable way to legalize the apartment for whatever reason, for any of those egress, for whatever, or if the building owner fails to pursue an option that would legalize the unit. So while I'm going to stay open to this conversation, I definitely have pause.
I don't know if this is any different from any different
And what?
coverage applications granted to loft buildings, right? If something doesn't work, the owner must take reasonable and necessary steps to legalize.
But what if, I know I'm not asking a question, rhetorically, but what if that
You can ask him
means...
a question.
I can ask him a question?
I'll defer to John.
Well, what if the only way to, I hate to think like worst case scenarios, legalize the unit is to combine it with the unit next door, or to cut it in half, or something, there's many units that are very obvious. Oh, we need to add a fire escape, or enlarge the window, or enlarge the door, or put a fireproof self-closing doors on all the doors. There's really simple logical stuff, and then there's these really big questions of what if there's absolutely no way to make this unit legal?
The second part I won't answer, right? But in legalization is a tough thing, right? I mean, we can't take anything away though from that possibility of just for folks to work towards legalization. The owner has to take all reasonable necessary. I mean, I'm sure the lawyers will figure it out. I'm sure the architects will figure it out. But this is my take. You don't deny coverage because the choices are different. In fact, in my opinion, that's one reason to grant coverage, let them work it out.
So I just have to play this out from the owner's perspective, even though I do understand, obviously, the concern that one way to deal with this problem is to let the owner take all reasonable necessary action, and if it comes back from DOB that this is not possible to legalize, then the board may have to decover the unit.
There's a lot of ifs.
Right.
Yeah, there's a lot of ifs there. I'm an architect, I've been working for years. We make everything work for our private clients. There's a lot of problem solving, a lot of things happen, so you're taking up a lot of time with this. You're a special guest here today.
I understand.
Keep that in mind.
The only thing I'm mentioning is just, I actually respect that solution, which is try to find a way to legalize it. The one problem is the way the law currently works is when the landlord isn't legalizing it, and they fall out of compliance with the deadlines, because they're having a lot of difficulty with legalizing the unit, then the issue of rent starts to become a problem. So I'm just pointing out that if the law allowed the owner to devote whatever time they needed to try to solve this problem, and only if it really wasn't legalizable, if we dealt with that, that would be fine. But the additional problem is that there's sort of this punishment that occurs where the owner can't enforce the obligation to pay rent if the deadlines are not met. And that's the danger with the way the law currently works with covering
Don't they
units.
have a remedy to go back to the loft? Board?
There's no mechanism I'm aware of for filing an application with the loft board to say, I can't legalize this unit. And the only time, I've only seen the loft board decover a unit once, and it wasn't for this issue, at least in the recent history of the loft board, it was for another.
There's mechanism, so you may want to revisit it then.
Okay.
Yeah.
I would like to say that I could not imagine the number of lot line windows in this city which provide light in there. And I think that there have been certain cases where there are lot line windows.
There are 0 lot line windows that provide light and air.
Pardon?
0 lot line windows
Well, but
provide light and
that's
air.
what we're talking about here. No, is that not the point you made, that the window into the courtyard is into somebody else's property? Does that not make it a lot
The
line
way
window?
it does, the way I understand it is that in order to be granted coverage, there has to be a window. Now, it doesn't say a legal window, it says a window, right? A window onto
Onto either corner or street.
But then, when the owner hires an architect and goes to DOB, does not have the same definition. It's a different, they're different regulatory agencies. So the window, so this is just saying the window allows for coverage. DOB doesn't necessarily have the same opinion. So when they get to DOB could reject it and say this window does not count for coverage, and therefore this unit cannot,
No, for legalization.
for legalization.
Yeah, I mean, DOB would not comment on the coverage piece, right?
Correct, right, for legalization. They'll say, no, this isn't a legal window, nobody can live here. And so now we have so then another solution can be found, or no solution can be found, and then that is no longer, that can't be a covered unit. Not because of the coverage portion, but because of the legalization portion.
Right.
Yeah, I can't possibly imagine the number of lofts that have been covered in this city, that perhaps if they came before us now, we'd have a certain amount of difficulty. Now, the law simply says that there's a window either onto the street or something. Why don't we just go along with it? And if something prior happens to it, I'm sure that it's possible that there's a window, a lot line window, looking out to somebody's backyard, that some landlord decided to put a building up right in front of it, in which case the situation would be different. Now, would we then go and delegalize that loft? I don't think so.
It would never be legalized in the first
Pardon?
place. It would never be legalized in the first place. So part
So
of,
what are we talking about?
part of 7B, so part of the multiple dwelling law that allows you to construct in commercial conversions has reduced yard requirements from 30 feet to 5 feet. There's a number of other, the skylights and a number of other issues that we've discussed. So, but never can you have a window on a lot line be the light and air for that unit.
But that doesn't seem to be the case in this order, or is it the case in this order? Coverage.
They haven't gotten that far.
The coverage, no?
They haven't gotten to the legalization part.
This case is not covered.
And so the one thing that connects these two concepts is my reading of 281.5, which at least at present has a requirement that the window be opening onto either the street, which makes it easy, or a lawful yard or court, is that if it's a lawful yard or court under the zoning resolution, if it meets that definition, it shouldn't be difficult to legalize and provide light and air. If you read it as being a yard or court that's on the zoning lot for the building in question, if you then come up with this matter of Doris interpretation that says it can now be the open space on the neighboring zoning lot, that does not provide that same protection to say that units are only going to qualify for coverage if it provides an obvious, very likely legalizability in terms of light and air. So that's
we're
the
not,
danger of this.
and we're not considering that now, and we're not considering this whole legalization thing and how difficult it is and how easy it might be, because this is about coverage. And is there anything any board member has here, or Mr. Frost, that you see some kind of legal impediment to granting coverage?
Right, well, what I'm saying is the language of 281.5 requires there be a legal yard or court on the zoning lot, in my view, and that it's up to the board to decide how to interpret that.
For coverage?
For coverage.
Oh, I see.
And the purpose is to prevent likely unlegalizable units, because it's unfair to the owner to put them in an impossible position and impose an impossible legal obligation.
Unless anybody...
No, architects know how to figure this stuff out. That's why we went to school, we're creative, we figure this stuff out. We've been doing it for years in all the different buildings all over the city.
Okay, so I need a motion that we have a motion. We need to vote.
Mr. Barros?
Yes.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Ms. Torres?
Yes.
Ms. Grossman?
Yes.
Chair Wilson Nixon?
Yes.
7 in favor, 1 absent.
Thank you, Mr. Rivera. But thank God, the next case is being tabled. However, it's the last case in the calendar, but we have our auditor, Loft Board Auditor Stan Pollock here, who did make a presentation, and we would like to give him the opportunity to present here today some material that was relevant to this case. So it's general information, so it doesn't even put the case in detail. Thank you, Stan. I think the board members, you have copies of the presentation before you. Everyone has, just give me a second, let everybody take it out. I'm sorry.
Owners, when they incur costs,
No, we don't have mine. Could you just test it for me? You do have that.
It's not working.
Okay.
Looks like there's some tape on here.
I'll speak louder. How's that? Okay. So, owners that incur costs for legalization can apply for applying those costs to the IMD tenants in the building if they submit a rent adjustment application. The rent adjustment application contains a schedule of code compliance costs for obtaining residential certificate of occupancy. The schedule contains costs established in September 1984, and since 1984, they are indexed annually based on the annual percentage change of September of each year using the Engineering News Record of Building Cost Index. And that's a weekly periodical, and we use that September index out of that periodical. Next slide, page. The schedule captures the following items. Allowable costs of materials and labor for demolition and construction necessary to achieve the minimal code compliance. It also captures professional and municipal fees, and there are separate sections in the schedule for residential units, commercial units, and common areas. rent adjustment application, the building owner files the rent adjustment application, completes the schedule of code compliance costs, item by item, those that are applicable to the types of construction and materials that he did for that building. He provides the actual cost including the number of units purchased, as well as square footage, whichever is applicable. And he also includes with that application files with the Loft board with vendor invoices and proof of payment, which would be copies of canceled checks, both front and back. Those documentation are used in performing the audit of the allowable cost. So the next page, page 5, we also the owner can include associated costs associated with obtaining and servicing the mortgage associated with compliance costs. This is the topic we talked about in the private section. The average annual, the cost of the average annual debt service, which includes interest, finance charges, and service charges over a 15-year self-amortization mortgage. The service charges can include application fees, commitment fees, professional fees, title exam, insurance, mortgage tax, etc. Once we receive the application and we look at the documentation, the costs submitted by the owner are checked against the documentary proof, the vendor invoices, and the proof of payment. Items that are not verified are disallowed. They're not part of the allowable code compliance cost. The allowable code compliance cost is the lesser of the schedule of index cost versus the actual cost of the owner. So that's on the line by line item, not as a total in the section. On each line, there's the index cost versus the actual cost. The lower of those two is what's allowable. Once that audit is done, we can calculate the residential per unit adjustment. It's determined in the following fashion. Allowable cost for a specific residential unit, that's by each unit. I apologize, there's a bullet that's not in here, and that relates to the common area costs that service only the residential unit. Those common area costs that support only the residential units are divided by the number of residential units in Wales. Next item, the allowable common cost allocated to each residential unit that's not part of just residential, but the common area is based on the percentage of residential square feet to the total square feet in the building. Architectural and engineering fees and legal fees are calculated at 7% and 4% respectively of the allowable code compliance costs of residential units determined above. Unless those architectural fees and engineering fees are less than that calculation. And allowable mortgage and financial costs, which we discussed earlier, are allocated to residential units based on the percentage of allowable residential unit cost compliance, as per the above, proportion to mortgage debt. And we also discussed that at the earlier session.
Thank you. Does anyone have any questions?
Yes.
How, is everything just done via forms back and forth, or is just out of curiosity, so is somebody assigned to each case that meets with the owner to go through to answer questions through the documents, or is it just like he submits, you review, and then you send an answer?
No, as we go through the application, we have questioned whether it's necessary cost for compliance. Sometimes we need additional documentation to meet some missing items. So there is correspondence back and forth between the auditor, myself, and the owner that submitted the application to try to get verification. Once we go through that process, sometimes in many cases, we don't get any further information, then we disallow it. We cannot determine necessary and reasonable costs. We have the appropriate documentation to verify that the nature of the item in the application. We disallow that.
Typically, how long does this process take?
It takes a while. These applications, some applications I've worked on were 7 or 8 years old before I touched it. This particular application.
Can I just say the reason for that is that we didn't have an auditor, so we had nobody to audit. When we got audited, they left before they finished.
Are you staying? My next question.
I actually work part-time, 2 days a week. I'm retired, and began working with the Loft board, a big bunch of people, by the way, for the last year and a half. As you know, we've been with 5 RA applications I've worked on, and have completed all of those so far.
I was wondering, on the rent adjustment application, provide documentation of actual costs. Is there a contract that you have with?
There's also contracts that are submitted just as part of the documentation. There could be POs, purchase orders, as well, that constitute contracts. So contracts, and then the subsequent vendor invoices, and then of course proof of payment.
First of all, before I ask a question, I really want to thank you for what you're doing. And I can tell you that there was a view in the practitioner community that there was just no point in even filing for legalization cost pass-alongs because it would delay getting through the process and out of the law court's jurisdiction so much that it just wasn't worth doing. So your work is very much appreciated, I think, certainly by owners and probably by everyone involved in the law firm. Thank you. And I guess my question, since I've never actually had the privilege of filing a legalization cost pass-along application, in part because of that reason, what is the scheduled index of cost and what is it based on?
Scheduled index cost is part of the new section of the
It's 29 RCNY 2-01P as in Peter.
and it's in there, and you can see the schedule of costs. So line item goes from demolition all the way through electrical, plumbing, construction, that has very specific items within that schedule. And as I said, started with as unit cost or cost per square foot or linear feet, as well as what the costs were back in 1984 when it was first determined. And then there's an index that's applied based on the cost, the construction cost index over those period of years that we update every year based on the September publication. And that is applied against the 1984 cost to come up to today's cost.
Okay, so there's some sort of index that's used that is current, and then that's sort of a formula that's applied to the base numbers from 1984?
Correct.
Okay. And I just don't know what that formula is. What I'm curious is how often when you compare owner's cost to the calculated schedule index cost, how frequently is the schedule index value the lower number of the two compared to the owner's number?
Very frequently.
Is it like 90% of the time it's the schedule index cost?
I haven't done percentage, but most of the time, the index cost is less than the actual.
Okay.
There are some instances where it's less, where the actual cost is less, but for the large majority of the items I reviewed, the index cost is less than the actual cost.
In your opinion, do you think that the schedule index cost is a good reflection of the market value for those items?
I can make that judgment.
Sorry.
Is there then, so it talks about minimum code compliance. Is there something in the process that determines whether it's considered minimal code compliance? I mean, that's sort of not an audit money question.
Mm-hmm.
So there's some that might be opinion, whether, I guess there's
It's
no
the final
opinion.
approved drawings, right? I
Well, I'm just trying to think of something like, if I install a $40 light or a $400 light. I mean, they both have the same wattage, they both meet the energy code in the same way, blah, blah, blah. Same with windows, you have certain fenestration requirements. You could have a $100 window or a $1,000 window that both meet the same code compliance.
But the cost that they have is the index cost versus the actual cost. So if you put in the example, if you buy a $100 light, but the index cost is only $95, $95 is the cost. If you, on the contrary, if you spend $400 rather than $100, but the index cost is still 95, you're only allowed 95.
Yeah, well, so where I'm seeing this is as these are all the things going on in my head right now. Like, so I'm going, okay, on the one hand, I get that that it tries to eliminate the potential for owners to price gouge. So they're not putting in door-and-brocked water fixtures when a Delta will do, right? On the other hand, you kind of also don't want them to install the cheapest everything. Like, it's like, oh, this is someone's home. They should get a good window. They shouldn't get a $100 window just because,
But the law allows them to do the minimal amount to legalize. And if that means the cheapest fixtures for those owners, they're allowed to do that legally.
Is that the index? That cheapest number, is that the index?
No, I think
Right.
It goes to
It varies by, right. So I guess I'm just thinking out loud and having kind of like
It's a
a
fair-
moral dilemma here.
I know where you're going.
Can I just say that we have had issues in narrative statement conferences where owners wanted to do one thing and tenants said, well, I don't really like that and I would like to upgrade, and they negotiate with each other about those kinds of upgrades. But the law only requires the owners to do the minimum, and that's the delta, not the whatever.
And again, the allowable cost is the index cost, so
Right.
whatever the owner actually spends on that one line item, all right, the maximum that's allowable is the index number or the actual cost, whichever is less.
So he's going to, a fiscally conservative owner would try to get as close to this index as possible when he's...
And I would just add, I think it'd be great when there is square footage issues that you have access to the approved file DOB drawings so that you're referencing how the architect listed square footage for the residential areas, the common areas, so that it's very clear what the actual square footage is, because that can become controversial.
And can I just make one more comment? One of the points that isn't in this presentation, because it's not necessarily part of Stan's process, although he does do the letters, is that when the audit is complete, we send the results of the audit to the tenants, the affected tenants, and the owners, and they have an opportunity to comment. So it's not that we do the audit and that's it. The tenants have a right to contest. So you could have an owner that said, I renovated 2 bathrooms in this apartment, and that tenant will come back and say, I only have 1 bathroom, I don't know what they're talking about. So I just want everybody to understand that the tenants do get the results of the audit, and they have a right to challenge it under the board's rules.
Yeah.
They get everything.
And in fact, you provided a copy of the letter in the
Yes.
case that we have, so you can
Yes.
see what.
And if a tenant requested that their bathroom get nicer fixtures, then you said they can negotiate that gets put in, then it's separate.
Well,
Then they pay for that, or no?
That may be a conversation between the tenant and the owner, something that has nothing to do with the application. Because again, the cost is what's allowable and it's in there.
So they may pay the difference for something on
So
front.
it
Well,
wouldn't
I
get.
can give you an actual example.
Okay.
In my loft, we opted to buy the tile for the bathroom floor. And the owner said, fine, you buy the tile, my guy will put it in. Now, had he applied for cost, obviously he wouldn't have included the tile because I paid for it. As it is, my owner waived the pass-along, which happens most of the time, perhaps in part, as Jason suggests, because of the paperwork involved. But in many instances, the cost of legalizing a lot of these units is pretty minimal, and it's just like, why bother? So,
Yeah, I think a lot of the 1982 era buildings had less units. A lot of them had front-facing windows. It just wasn't quite as onerous. And then certainly there are plenty of buildings in Brooklyn. The variety is a lot greater, I think, in the kind of buildings. It can just vary a lot. If you have a 3-unit building, you're probably not as concerned about it than if you have 90-something unit buildings.
Thank you. Thank you, Stan. I appreciate it. Thank you.
Please continuing or we're going to adjourn?
Are we on?
We have, I was told, we have 5 minutes. Can you give 5 minutes?
I have a quick
question.
comment on, so one of the documents has the incorrect address. The documents that were given for 873, 879 Broadway, it says AKA 25 West East 28th Street.
Is it?
Instead of 18th Street.
All right, we'll correct it.
All right, on the order itself.
No, on the table of contents of the backup documents.
Oh, okay.
should be 18.
Is it also on the order?
The order says East 18th Street.
Right, the document, the backup. Yeah.
Okay,
All
well,
right,
the backup,
we'll fix
yeah,
that.
we can fix the backup, but.
All right. Mr. Frosch had a comment or so you want to make on the legislation. I just want to caution, because the legislation is not the Loft Board's, this board's legislation is, as you know, right? But so I don't know how much we can actually debate it or anything, but let's be free, you get 2 minutes.
Thank you. I'll just remind that the 2 biggest issues, I think, affecting everyone that has an interest in this, even if your interest is just being on the law board and this is the direction these cases are going to end up going in and you're going to have to decide them, those 2 issues are incompatible use, which hasn't reached the board yet. The way that's being altered in this law takes what qualifies as an incompatible use that makes it difficult to cover the building because it's potentially problematic for having mixed use in the building. And makes it much smaller. So more buildings under this language will be qualifying for coverage, notwithstanding that there could be some concern in commercial occupancy. And then 2, the window requirement that we were just talking about, deleted, gone. So units can qualify if they have no window whatsoever, meaning even if they're in the middle of the floor and they don't even have an exterior facade.
For coverage.
For coverage.
Yes.
They would be covered under the proposed language, and then it would be the owner's obligation, with serious penalties for not being able to do so, to somehow legalize a windowless unit for residential use and have to see it. So those are serious.
I don't know if that's true if the owner is taking all reasonable and necessary steps.
Well, I do not know how, and again, maybe the architects can tell me.
When you said they'll be punished, I'm saying, how would they be punished if they're taking more reasonable necessary?
Well, even if they can get the coverage, once there's a determination that it's unlegalizable, during the entire period it takes to go through that process, deal with any appeals to that process, there may not be any payment of rent. There may be significant costs in terms of trying that process only to be told that it's not possible. And there are real outcomes to having this presumptive obligation that you have to work very hard to either figure out whether you can comply with it or be told you can't. It's a serious consideration.
Understand. Any other?
I have a question.
Yes.
Mr. Frost. This email came in to Executive Director Paulson at 12 12:04 PM.
You're asking him about?
Yes, came in at 12:04 PM. You seem to be fairly understanding of some of these orders.
Yes.
Why is that? It takes me several hours to go through the orders, and you did it in less than an hour.
He's a smart guy.
He's younger than you are.
What I'll say is, one, a couple of these were sent to my firm. That's usually the practice, is that the law court staff sends them to firms that I've had some connection to the building or are currently representing one of the parties. So a couple of these I've seen for that reason. The other, the answer is I read these constantly, so in the 10 minutes that I had, since they were handed to me, I just kind of read them and figured out what that's
Okay.
I had a comment about
That's what I think I remember you said something.
I know.
There's a motion to extend.
A motion to extend the meeting?
No, we're making a motion to extend this process so that next week we don't have to go to the regular vote.
Oh.
No, well, so yes, there was that, then there was, so I've been to the last, I don't know, 5 North Brooklyn Community Board 1 meetings, following along with all of this, what's happening in Albany, because being someone who has lived and worked in North Brooklyn for the last 26 years, definitely have a stakeholder there, and it predominantly applies to North Brooklyn. You have the exception in the North Brooklyn IBC and all these things. So I did have a comment, but I've forgotten what it was. Sorry.
I guess I just have to ask the question of the private meeting issue, since if my continued participation is addressed in the public meeting next month, that will be moved at that point.
You vote for next month.
Right. So I guess I'm
At this
wondering.
point, it is.
So that I guess you're saying the decision is not to permit me to be Mr. Carver's designee for the private meeting next month.
That decision hasn't been met yet, but yes, it's default. Because that decision will come at the public meeting next month, which will come after the private session.
Understood?
It was nice having you.
Thank you. I really do appreciate it, and I
Thank
hope it didn't catch anyone by too much surprise.
That's fine. Thank you. I appreciate your insight.
Makes me feel like the board and your law firm are like, it seems very, as a citizen, I find it a big conflict of interest.
I really do understand it and respect that. What I'll
Like,
say
I have
is-
to ask you if you're part of the case or not.
Can I just say, we really need to leave, because we're gonna have, like, they're gonna kick us out of the room, so.
All right.
Can we take the?
Can I just,
from this corner to the
we're
coffee
not
shop?
taking this to the hallways.
To the bar?
No, to the bar, maybe. All right, let me just read my spiel. Okay. This will conclude our May 16th, 2019 Loft Board meeting. Our next public meeting will be held on Thursday, June 20th, 2019 at 2 p.m. right here at 22 Reed Street, Spectrum Hall. Board members, please remember to sign in and hand the attendance sheets. Thank you.